At the conclusion of this lecture, you will be able to understand the meaning of and procedure involved in voluntary liquidation, including members' and creditors' voluntary liquidation. You will understand the meaning of, the grounds for, and the procedure involved in compulsory liquidation, and the order in which company debts will be paid off on liquidation. Winding up, or liquidation, is the process whereby the life of the company is brought to an end and its assets realized and distributed to its members and/or creditors. The rules governing winding up are detailed in the provisions of the Insolvency Act of 1986, and the exact nature of the procedure depends upon the type of winding up involved, and depends upon the solvency of the company at the time when liquidation commences. There are three types of liquidation: voluntary liquidation, creditors' liquidation, and compulsory liquidation. Winding up can be conducted on a voluntary basis, in which case the members of the company themselves determine that the time has come for it to come to an end, or, alternatively, the court may make an order that the company's life should come to an end. Section 84 of the Insolvency Act governs this area and provides that a company may be wound up voluntarily. When any period fixed for the duration of the company by the Articles expires, or any event occurs which shall, according to the Articles, lead to its dissolution, under such circumstances, the winding up has to be approved by an ordinary resolution. For any other reason whatsoever, under these circumstances, a special resolution is required to approve the winding up. This is the procedure the members would follow if the company is insolvent. In any case, the winding up is deemed to have started on the date that the appropriate resolution was passed. A member's voluntary liquidation takes place when the directors of the company are of the opinion that the company is solvent and is capable of paying off its creditors. The directors are required to make a formal declaration to the effect that they have investigated the affairs of the company and that, in their opinion, it will be able to pay off its debts within 12 months of the start of liquidation. It is a criminal offence for directors to make false declaration without reasonable grounds. On appointment by an ordinary resolution of the company, the job of the liquidator is to wind up the affairs of the company, to realize the assets, and distribute the proceeds to its creditors. On completion of this task, the liquidator must present a report of the process to a final meeting of the shareholders. The liquidator then informs the registrar of the holding of the final meeting and submits a copy of their report to them. The registrar formally registers these reports, and the company is deemed to be dissolved 3 months after that registration. On completion of the winding up, the liquidator calls and submits the report to the meetings of the members and creditors. The liquidator then informs the registrar of the holding of these final meetings and submits a copy of their report to them. The registrar formally registers these reports, and the company is deemed to be dissolved 3 months after that registration. A creditor's voluntary liquidation takes place when the company is insolvent, when it is decided to wind up. The essential difference between this and the former type of liquidation is that, as the name implies, the creditors have an active role to play in overseeing the liquidation of a company, and there is no declaration of solvency. The purpose of the liquidation is to appoint a responsible person who has a duty to collect the company's assets and distribute them to its creditors, in accordance with the law. That person is the liquidator and must be a licensed insolvency practitioner. A meeting of creditors must be held within 14 days of the shareholders' meeting at a venue convenient for the majority of creditors. Notice of the creditors' meeting will be sent to all known creditors at least 7 days before the meeting, which will also be advertised publicly. Creditors are entitled to inspect a list of names and addresses of the company's creditors prior to the meeting. One or more of the directors will swear a statement of affairs of the company, which summarizes the assets and liabilities, including details of creditors' claims at a date not more than 14 days prior to the date of liquidation. the creditors vote to appoint a liquidator. The votes are based on the values of the creditor's claims. A liquidator's powers are wide and include powers to sell the company's assets, to bring and defend legal proceedings, and to pay dividends to the company's creditors. Some of the liquidator's powers can only be exercised with the agreement of the liquidation committee, the creditors, or the court. Creditors may still pursue actions against the company, although this might lead only to more unsecured claims in the liquidation, as creditors are not entitled to enforce recovery. The liquidator may apply to court to stay any proceedings. It is only in certain specific instances, for example, if the company has insurance cover in place that may be used to pay your claim or you claim ownership of specific assets, that it may be appropriate to commence legal action against the company. A compulsory winding up is a winding up ordered by the court under Section 122 of the Insolvency Act 1986. Although there are 7 distinct grounds for such a winding up, the most common reason for the winding up of a company is its inability to pay its debts. It is advisable to have a look at this provision to see the other grounds for compulsory liquidation. Section 123 provides that if a company with a debt exceeding £750 fails to pay it within 3 weeks of receiving a written demand, then it is deemed unable to pay its debts. On the presentation of a petition to wind a company up compulsorily, the court will normally appoint the official receiver to be the company's provisional liquidator. The official receiver will require the present or past officers, or indeed employees of the company, to prepare a statement of the company's affairs. This statement must reveal particulars of the company's assets and liabilities, names and addresses of its creditors, any securities held by the creditors, fixed or floating charges, and the dates on which they were granted, any other information which the official receiver may require. After his appointment, the official receiver calls meetings of the company's members and creditors in order to select a liquidator to replace him and to select a liquidation committee if required. In the event of disagreement, the choice of the creditors prevails. Section 142 of the Insolvency Act 1986 states that the functions of the liquidator are to secure that the assets of the company are got in, realized and distributed to the company's creditors and, if there is a surplus, to the persons entitled to it. Once the liquidator has performed these functions, he must call a final meeting of the creditors, at which he gives an account of the liquidation and secures his release from the creditors. Notice of the final meeting has to be submitted to the Registrar of Companies, and 3 months after that date, the company is deemed to be dissolved. Secured and preferential creditors are paid before unsecured creditors. Secured creditors are those that have some form of security over a company's property, for instance, a bank with a fixed and floating charge debenture. Secured creditors are entitled to be repaid their debt out of the proceeds of sale of the secured assets in priority to ordinary unsecured creditors. Section 175 and Schedule 6 of the Insolvency Act set out what are to be treated as preferred payments, and these are essentially wages of employees together with all accrued holiday pay, £800 maximum. This is referred to as preferential creditors and are a special category of unsecured creditor. Creditors secured by floating charge. Ordinary unsecured creditors. This category is one that stands to lose most. It comprises the customers and trade creditors of the company. As creditors, they rank equally, but, as is likely if the company cannot fully pay its debts, they will receive an equal proportion of what is available. The deferred debts of a company. These are debts owed to the members as members. For example, dividends declared but not paid. Members' capital. After the debts of a company are paid, the members are entitled to the return of their capital, depending on and in proportion to the provisions of the Articles of Association. Any remaining surplus is distributed amongst the members, subject to the rights given in the Articles of Association or other documents. In conclusion, liquidation is the process whereby the life of the company is brought to an end and its assets realized and distributed to its members and/or creditors. There are three types of liquidation: voluntary, creditors, and compulsory. Voluntary liquidation is where the company is still solvent. Creditors liquidation is where the company is insolvent. Compulsory liquidation is through court order. Once liquidated, debts owed are dealt with through a legal system.